My name is Ruth Heintz, and I want to welcome everybody to this property tax relief webinar that's being put on by myself and by attorney Stephen Buckley from the Municipal Association. We're trying to get just information out about what is property tax relief and how to implement it in New Hampshire. And we've sent the information, I know, through the Municipal Association, also through the Tax Collectors Association. So I'm not quite sure in what capacities different people are participating, but we welcome any kind of questions in the chat. And while I'm presenting, Stephen will be monitoring the chat for questions and popping them to me. And then when he's presenting, I'll do the same for him. So please put any questions you have in the chat. And we'll also afterwards make available this PowerPoint. It's actually quite long. It's almost 100 slides. And some slides I will spend a lot of time on, and others I'm just going to gloss over. I really wanted to make it comprehensive, so it's really a large amount of information. But I'm really going to focus on the parts that I think are most important for people to know. So
and just let me say a few words, Ruth. I just want to say thank you for having me join you to help make this presentation. And so after Ruth is done, who was really doing the heavy lifting on most of these property tax relief statutes, I'm going to give you, it's about 16 slides long, just an overview of the ways in which towns carry out implementation by warrant article and other changes by vote of the town meeting on some of these particular exemptions, and also some degree of focus on the tax deferral statute. So I'll just turn off my microphone and my camera and be available to assist Ruth in answering questions. And I'll pop up later on to do my slides on some of the implementation and warrant article issues. So again, thank you for having me join you today, Ruth.
Thank you. And I really appreciate you taking the time and also spreading the word about it. And when Stephen and I initially talked about this, it became clear that we also have obviously different perspectives on some of the statutes. And I may say this is how I interpret a statute, and Stephen may do the same as far as how he interprets a statute. So you'll have an idea of really different ways of looking at it and different ways of advocating and implementing. So, but I will just get a start on this. So what is property tax relief? Property tax relief is a reduction, a postponement, or forgiveness of property taxes for homeowners who cannot afford their property taxes. The requirements for property tax relief are set out primarily in New Hampshire statutes. There also are some administrative regulations. Most forms of property tax relief are administered by municipalities, and some forms of property tax relief are required, while others are optional. Some property tax relief, municipalities may decide on the parameters of the relief, how much income or how much in assets people have to qualify, and how much they will grant of one kind of property tax relief or another. So there are 4 different types of property tax relief that we talk about. A credit is a reduction in the amount of property taxes payable in a given year. So it's an amount taken off the taxes that are calculated. An exemption is a reduction in the value of the property which is taxed. So less of the property is taxed if somebody gets an exemption. A deferral allows the homeowner to pay the property taxes at a later date at a reduced interest rate and without the risk of tax deeding. And an abatement is a forgiveness of taxes based on an error in the assessment calculation, a disproportionate assessment, or poverty and inability to pay. And I'm solely going to focus on the poverty and inability to pay. This getting into errors on assessments and disproportionate assessments is beyond my expertise. How does a homeowner apply for property tax relief? So we hope that the city or town's tax collector or the selectman's office or other designated employee would have applications on hand. And we also would hope that all municipal employees would know where to direct somebody, a homeowner that asks for help regarding their property taxes. And I would also hope that applications should be available whenever municipal offices are open. So there are several different forms. And the first three are put out by the Department of Revenue Administration and available on their website. The PA 30, it's called the Elderly and Disabled Tax Deferral Application. Then the PA 29, the Permanent Application for Property Tax Credits and Exemptions. Then there's the DP 8, which is a Low and Moderate Income Homeowners Property Tax Relief, which is a state program and administered by the state. And as I said, these forms are all available through the Department of Revenue's website. And people can also call the forms line. I checked the number. It's actually, it's not you dial extension 1 once you get to the Department of Revenue Administration on that phone number. And then there is a form for abatements that is actually available on the Board of Tax and Land Appeals website, or by calling the Board of Tax and Land Appeals. And it also has a specific name, Taxpayers RSA 76:16 Abatement Application to Municipality. So the deadlines for applying for property tax relief. So there's a really close deadline, and I had hoped to get my act together for this earlier, but I didn't. So the March 1st deadline for tax deferrals and abatements is coming up. So the deferrals, if somebody applies for a deferral now, it would be a deferral of the 2021 property taxes. And an abatement would be 2021, or it could also be previous years before that. April 15th is the deadline to apply for exemptions and credits, and that would be for the 2022 property taxes. And then the filing period for the low and moderate income homeowners property tax relief program is between May 1st and June 30th. And typically that form for that is actually not even available on the DRA website until closer to the opening date. How does the town or city determine whether a homeowner qualifies for property tax relief? The municipality typically requests documentation, including a form. There's actually a form on the DRA website, and it's also spelled out a little bit in RSA 7234. But towns may also develop some of their own forms or have additional requirements. Sorry about that. So for some types of tax relief, there are specific income and asset limits. The information and documentation, again, this is my opinion, should not go beyond what is required to make a fair decision under New Hampshire's laws. And then the privacy and dignity of homeowners should be respected throughout the property tax relief process. And again, I'll show later on, there's a form that the DRA puts out that requests the information about the income and assets. So what happens next? The town or city has until July 1st to make its decision whether to grant the property tax relief. If the taxpayer disagrees with the town or city's decision, or there's no decision, the taxpayer may file an appeal with a superior court or the Board of Tax and Land Appeals by September 1st. The BTLA has an appeal form on its website, taxpayers RSA 7234A exemption deferral or tax credit appeal to the Board of Tax and Land Appeals. And actually the same form, it's targeted at all, it's a little bit confusing because it's targeted at the different forms of property tax relief, but it covers all of them. Okay. And there's also an application to waive the filing fee available on the BTLA website. Otherwise, the filing fee is $65. There's a little bit of background chatter. I don't know if it makes sense for anybody to mute themselves. Just thanks. So I'm not going to read all, well, actually I will glance over these. So these are the key statutes that cover all the different forms of property tax relief. Deferrals, the elderly exemption, exemption for the blind, exemption for the disabled, exemption for improvements to assist persons with disabilities, exemption for deaf or severely hearing impaired persons, and then different veterans credits, the standard and optional, the all veterans tax credit, an optional tax credit for combat service, a surviving spouse tax credit for service-connected total disability, and the total exemption for houses that are paid for by the Veterans Administration for certain disabled veterans. And then this is the abatement statute at the bottom. So I start with deferrals because deferrals are my favorite type of property tax relief. And sadly and shockingly, some municipalities do not, I want to say, offer deferrals, even though they are required by the law. But I repeatedly have encountered towns that just literally have not offered deferrals. And it's just really important that all municipalities are aware of deferrals. And if somebody comes in saying, that they're having trouble paying their taxes, that they mention deferrals for people that might be eligible. So deferrals are available for people at least age 65 or who are receiving, this is the Social Security Disability Insurance benefits or SSI benefits. So if somebody is under age 65 and they're getting Social Security disability benefits of some sort, whether it's Social Security or SSI, they can apply for a deferral. If the person is applying based on being 65 or over, then they have to have lived there at least or owned the house for at least 5 years. If they're applying based on a disability, then they have to have owned the house at least 1 year, and they have to be living in the home. And now down here at the bottom, this is where it gets a little dicey or difficult. So the assessing officials may annually grant a person qualified under this paragraph a tax deferral for all or part of the taxes due, plus annual interest at 5%, if in their opinion the tax liability causes the taxpayer an undue hardship or possible loss of the property. So any of the highlights and underlining in this has been done by me, so it's not in the actual statute. So again, the key is the tax liability causes the taxpayer an undue hardship or possible loss of the property. And that is unfortunately not a defined phrase anywhere. And I've seen some municipalities that really apply too strict a standard that make a homeowner account for every last dollar spent. And I don't think, in my opinion, that is appropriate in the context of a deferral. This is more
before you go on, Ruth, just we have one question here. You had mentioned that you're aware of some communities are not offering the deferral. Do you feel comfortable telling us who they are?
I don't think I want to throw anybody under the wagon.
Okay.
So I don't. So I mean, the ones I've encountered through working, through dealing with us basically now are aware, but I don't need to throw anybody under the wagon. So. Okay. I just encourage, people to make themselves aware and ask questions. I'm open to questions, and the Municipal Association is there to answer questions. So I really just hope that if anybody has questions that they reach out to get more information about them. So the deferrals, the total of tax deferrals on a particular property shall not be more than 85% of its equity value. So this is key. So this is in part to protect the municipality. So often, let's say if it's a senior or somebody age 65 or older who is applying for the deferral, they may have paid off their house, and they may have a lot of equity value to work with as far as deferring their taxes. They may be able to defer their taxes for as long as they want to live in the house. If it's somebody younger who still has a mortgage, then there may be less equity to defer taxes. If the property is subject to a mortgage, the owner must have the mortgage holder's approval of the tax deferral. Such approval does not grant the town a preferential lien. So again, here is where that 85% and that 15% cushion is important. So again, that there's a little bit of a cushion to help protect the town. This first part makes it obviously more enticing for the mortgage holder to sign off on the deferral, and the form actually requires a place where the mortgage holder must sign off. And sometimes it's very difficult for a homeowner to get their mortgage company to agree. Any assistance that can be provided in that is appreciated, or reach out for legal assistance. And then at the bottom, note also a tax deferral shall be subject to any prior liens on the property and shall be treated as such in any foreclosure proceeding. So the deferrals continue until the homeowner dies, and there's some provisions here, or when the homeowner sells the property. So again, they just stay on the property indefinitely until the homeowner dies or the homeowner sells the property, and accrue 5% interest a year. This is not great for seeing it, but I did want to include the form, and it's a 3-page form. The first part, the first top part here is the part that's completed by the homeowner. It's just very basic information. What is the amount of taxes? How much are you asking to have deferred? And then on what basis you qualify? And then this is actually the signature line for the homeowner or homeowners. The second page, top is for the mortgage company to sign off. And then the next part is for the town or city to fill out. And it shows here amount of taxes deferred in prior years, amount of tax deferred in current year, and then they add it up so you can see immediately, make sure that they're still below the 85% threshold. And then some more lines in the signature. And then the third page has instructions, very detailed instructions for both the taxpayer and for the municipality. So I wanted to bring up this. This is a fairly recent decision from the Board of Tax and Land Appeals. And the reason I wanted to highlight it is because of what I mentioned earlier, that some towns really have made people account for every last dollar they spend in a year before granting a deferral. And I think the Board of Tax and Land Appeals agrees that that's not the standard. And I'm going to read this because the standard, as we'll talk later, for abatements is a lot more stringent. But for deferrals, it is not as stringent. And the key is in an abatement, the taxes are never recouped by the town, whereas in a deferral, the town will get paid. So the standard for granting a deferral by design are less severe than the standards for receiving an abatement of taxes due to poverty or inability to pay. As interpreted by the Supreme Court, RSA 7616, and that's the abatement statute, requires taxpayers to demonstrate it would not be reasonable for them to relocate, refinance, or otherwise obtain additional public assistance in order to receive an abatement. If an abatement under the Ansara standard is granted, there is no recouping of the tax loss by the municipality. RSA 7238A, which is the deferral statute, the tax deferral statute at issue in this appeal does provide for the municipality to be reimbursed the full amount of the deferral plus interest when the property is liquidated. In light of this statutory framework, the board finds taxpayers can qualify for an RSA 7238A deferral without necessarily showing they are entirely destitute. Instead, this statute allows them to tap the equity of their house to produce a living situation that avoids undue hardship or possible loss of the property. So again, I really ask municipalities to look at deferrals with this in mind, the tapping of the equity. Excuse me. So I think, you know, a homeowner that asks for deferral should be allowed to have pets. They should be allowed to go on a trip to visit children or grandchildren. You know, again, they should have, you know, they are not required to be destitute. You know, the word tap evokes for me really almost a reverse mortgage kind of situation, which in a sense it is. But it's not one that, you know, is usury. It's a reasonable system. Deferrals are win-win. So it allows homeowners to stay in their home, which is preferable to most homeowners. They don't want to leave their home, especially as they are getting older. And you see homeowners that have bought properties 30, 40, 50 years ago, and especially let's say it's a desirable property on a lake or with a view, was very inexpensive at that time and now is ridiculously expensive. And in that situation, the person can defer the taxes and, in many situations, live out their lives in their home, and enjoy what they have worked for, and also, as far as, quote, not be a burden on the state. So it really, and some towns will say, well, then we'll have all these properties deferred, and, and somebody else has to pay the taxes. But really, if a municipality is deferring taxes all along, there might be ups and downs to some extent, but really, people are going to probably, for the most part, die at the same rate fairly consistently over time, except when you have a pandemic. So really, they're deferring a certain amount of taxes in a year, and then they probably will be collecting on a certain amount of taxes in a given year. So I think the financial hardship on the municipality should be virtually non-existent, except for time that's spent administering the deferrals, which obviously is not negligible. But again, I really think this is a win-win program, and really hope that all towns and cities in New Hampshire are offering it to their homeowner taxpayers, as they are required to do. This is not an optional program. This must be available, and people need to know about it.
Ruth, we have one question that kind of is a rejoinder to your point of view. Goes as follows. We have 12 homeowners with many, many years of deferrals on the books, with a total of $265,000. Yep. In the short 2 years I have been here, I see that all the deferrals we have had over the years sit on the books until they pass away, and then it gets tax deeded and the city eats up all the costs. So I tend to agree that we get this money over time. I don't know how you address that particular point of view.
So, so that's interesting. So that it would get, I guess that is possible, that it would get tax deeded. And I agree that in the tax deed context, there could be, again, given the nature of that the value of a tax deeded property may auction off for less than the 85%. But overall, really, again, if they are on the books and, have started, let's say, years ago, roughly it should be happening at the same rate that the town is collecting on the properties as taxes, as they are also deferring them. I don't know if what is your thought on that, Stephen?
Well, it was interesting. I actually was talking to a town today that was getting a substantial return, if you want to call it that, on unpaid taxes on a deferral. And they actually were trying to figure out how the money would end up in the general fund and get expended. Of course, it needed to be an appropriation, but I could certainly see where a tax deferral that goes on for an extended period of time, and there is, given other liens on the property that precede the lien that you get with the tax deferral approval, that this could occur, that you may not be able to have, the benefit of getting this taxes paid when the person does eventually pass away. So I think it's context specific, and maybe what it requires is the towns be very diligent in monitoring, these tax deferrals, and recognizing at some point you're going to exceed the 75%, 85% ratio that would permit someone to have a tax deferral. Now, that might put it back on the books in terms of the person have to pay taxes, and it might result in a tax deed. And yes, there's that issue. I could certainly see that happening. I think it really depends upon, how well the town manages the deferral program, and recognizing when it may not be appropriate to grant a deferral, given the amount of actual equity and the 85% limit. So I haven't dealt with a lot of this in terms of inquiries to the legal advisory service, but I could certainly see this person's point that you could end up in a situation where after a long period of time, you may end up getting tax deeded anyway, and that's kind of reality.
Yep. Yeah, and I would hope that those are the fewer situations where, and again, that the town, like you said, follows on the 85% cushion, the 85, so that they have the 15% cushion. And also the form that is used for the deferrals it doesn't really show on that calculation necessarily the interest, so that I mean, the town obviously would also have to keep the interest, in mind as well there, to make sure that, again, that they're getting their full, that they cut it off at 85%. And then really, then it's the town's, then really the homeowner could apply for an abatement. But again, that's a stricter standard. So
the other thing I would say is that someone else has just pointed out that in their experience, the properties that were subject to a deferral have not been tax deeded, and the family sell the property without much effort, and then the city gets the taxes plus the 5%. So obviously there's 2 points of view there. But the other thing I think is important, I have seen this in certain contexts, especially with trying to understand the relationship you have to the homeowner, and trying to make sure the person does become someone who you have to provide local assistance to. And it might be more effective to use the deferral statute rather than having to provide local assistance to keep that person in their home. So it becomes kind of a case management issue. You may have to have a close consultation between, the welfare director and the tax collector and the select board to figure out what's more effective in terms of keeping this person in their home. Is a deferral more effective, or to provide local assistance? And so we have to look at it from a more global point of view, I think.
Yeah, that's great. That's wonderful. And that's actually a really good point. And if somebody applies for a deferral, that was another situation we've encountered. And actually the Board of Tax and Land Appeals has addressed that as well, that it's the town cannot say you must take the local welfare. So if the person applied for a deferral, they still should be granted the deferral. But I think it makes a lot of sense for the town to look at, if somebody applies for local welfare, to say, hey, why don't you apply for a deferral? Because I think that's great.
There's another question here. I'm not really sure how to answer it. The question is, can you use the interest accumulated in the calculation of the 85%? My understanding was you could not. I'm not really sure what that question is asking.
Oh, so that's, yeah. So that I honestly don't know the answer to that, because I don't know if I would hope it would be, but I'm not sure. So because I'm not sure that the statute addresses, let's see, I'm just going back to the part of the statute that talks about it, but I don't know. 85% total amount which may be deferred. The total of tax deferrals on a particular should not be more than 85% of its equity value.
I think the interest is just something the town's going to get on top. I'm not sure how you calculate that into the 85%. I would just, a couple of other questions, a couple of observations that are here. The RSA on tax deferrals does need work from this particular person's point of view, because the municipality doesn't recoup the cost of registry filing fees. Okay, there's a registry filing fee, and that's not something that gets recouped. Yep. So I guess there's some argument there that there's some cost to the municipality. Obviously, those are the kind of things that the select board should weigh in trying to make these judgments as they're granted a deferral. But again, from my perspective, I've seen it in particular circumstances. It was a lot more effective to consider giving someone a deferral rather than providing them for welfare assistance, local assistance, which they probably could have qualified for.
That's great. Yeah, no, I agree. And I think also, really the local welfare again is often a stricter eligibility standard than I would say is required for a deferral. That I think the deferral is more lenient, that again, you can have some expenditures that aren't bare necessities as far as a deferral, versus often if you go for local welfare, it really, you're looking at the bare necessities, because often the person isn't a homeowner, and there's no lien to collect on anyway. So it's usually a pretty bare necessity standard. So I'll move on. But again, if anybody has more questions or comments on this, I would welcome them too. So on this, this statute states the interest on tax deferrals for the elderly and disabled granted pursuant to RSA 7238A will accrue at 5% beginning 30 days after the date of the final tax bill. So my interpretation, and again, Stephen's may be different, is that there shouldn't be any 8% interest on it after the 30 days of the first tax bill. That really the only interest will be starting 30 days after that, usually December tax bill. So the due date of the December tax bill. If then later the taxes get deferred after March 1st, then the interest would go back to 5% starting 30 days after the second tax bill. So I'm going to move on to exemptions and credits. And I'll start with what really is the biggest, well, first I'll start just with an overview. Sorry, this is the exemption and credit form. Sorry. And I'm sharing this form because it really is sort of a snapshot of all the credits and exemptions. So after the top section for the owner and applicant information is the veterans information. And it lists the different veterans programs. So the veterans tax credit, and again, this is really, really informative. It includes the statutes. So the standard credit of $50, optional. So this is if the town can enact a higher amount from 51 to 750. The all veterans tax credit, which is a different, that substitutes for the original veterans tax credit. There's a service connected total disability, and I'll go into these in more detail as we go through more slides. Tax credit for the surviving spouse, a combat service tax credit, sorry, if adopted. And then there's a certain disabled exemption, veterans exemption. Sorry, here is some information about the military service. And then this is the exemption for people age 65 and older. And then another exemption for improvements to assist persons with disabilities. So these are required exemptions. Below here, it shows local optional exemptions. However, the blind and the deaf exemption actually is not an optional exemption. There is a smaller amount that is optional, and then towns can implement a higher one if they want to. So these really belong up here in my mind. And then there's other ones that are optional for electric energy storage systems, solar energy systems, wind power energy systems, and wood heating energy systems. And then some more information on the applicant, so as far as residency to determine if they qualify. So this you can see is page 1 of 5. I think the second page is the part that's filled out by the municipality. And then there are actually 3 pages of instructions. I did not include all that information, but again, it's all available on the form. And this is a form that most municipalities are very familiar with the exemptions. So a minimum exemption of $5,000 is required for people that are 65 or over. And then the net income limit must be no less than $13,400 for a single person or $20,400 for a couple, a married couple. And then the net asset limit must be no less than $35,000. And municipalities may enact a higher exemption and also higher income and asset limits. And then these are again, this is the requirements in the statute that the person has resided in this state for at least 3 consecutive years preceding April 1st in the year in which the exemption is claimed. And then the income, and just explaining the income and the assets. So obviously the property they're living on is excluded, as are 2 acres or the minimum lot size. I think also some ancillary buildings. It talks about, again, net assets. Here it talks about that related structures such as an unattached garage or woodshed. And I'm just gonna, this is again, just more of the statute. I'm gonna just skim over it. So this is procedure for adoption and modification of elderly exemption. So an elderly exemption based on assessed value for qualified taxpayers may be granted for a different dollar amount determined by the town or city to a person 65 years of age up to 75, to a person 75 years of age up to 80, and to a person 80 years of age or older. And under no circumstances shall the amount of the exemption for any category be less than $5,000. So this is really if I was more adept at Zoom and juggling screens, I would actually go to this. So this is a list of all the credits and exemptions by municipality alphabetically. This is by county. And then this is the general link to a whole bunch of different tables on the Department of Revenue Administration's website. So it collects all kinds of statistics, really fascinating. I could lose hours there. I did copy one of the tables here, or part of one of the tables, just to show how greatly the values vary. So you look at Bath in Grafton County, and they literally have the bare minimum exemption for people age 65 and older. It doesn't vary, stays at $5,000. And just to note, this is from 2019, so I'm not sure if they've changed it in the last 2 years. And interestingly, in Bath, they only granted 3 exemptions in that year. And then you look at this one is really great. So you look at Auburn in Rockingham County. And so their exemption starts at 150,000, goes to 210,000 for people that are 80 and up, and has granted, it looks like 13 exemptions in that year. But I mean, obviously that reflects partly the property values in the municipality, in the tax base, I suspect as well. And whether, anybody in the town is proactive probably about raising the amount of the exemption, but it really shows how much it varies. This is the second part of this table. And again, looking at the income limits. So I'm just looking at Auburn in Rockingham County again. You can see that's a higher income limit. Look at Amherst. You can look at their income and asset limit, even a really high asset limit here. So that's, again, assets other than the home. And then this last column shows total. So that's the total of exemptions that were granted, it looks like. And then this shows probably the impact on the tax rate there. So again, this table is on the DRA website, and there's also other tables and further columns that show other exemptions and credits, but it's just really fascinating to see what is available in different municipalities. This is a form also available on the DRA website. This is a worksheet form that can be used by the municipalities. It's targeted at the exemption for people age 65 and older, but can also be used for the exemption for people for other exemptions as well. And it's a 3-page form. Again, collects the basic. Here's where the municipality can put in the information of what their income and asset limit is, and then collect the information about the income and assets of the homeowner applicant. And this is, again, a 3-page form that's put out by the DRA. So the exemption for the blind, again, a minimum exemption of 15,000. And I'm going to just jump through a lot of this. So has to have been a New Hampshire resident for at least 5 years. And this is the exemption for improvements to assist persons with disabilities. So this is another mandatory exemption. So a person with a disability is a person who, by reason of a physical defect or infirmity, again, this is kind of outdated language, permanently requires the use of special aids to enable him to propel himself. So basically, the amount of value that those improvements add to the house, those are exempted from the tax value. An exemption granted under this section shall have no effect on an applicant's eligibility for other exemptions as authorized under this chapter. So the exemption for the deaf or severely hearing impaired, again, a mandatory exemption of at least 15,000, and then the municipality can increase the amount of it. And partly one of these statutes has in there that it's basically meant to keep up with increasing property values, the increase of the exemption amount. This is also under the hearing and deaf exemption. In addition to the exemption provided in this section, a person may claim an exemption for improvements to assist persons who are deaf or severely hearing impaired as follows. So again, a similar one to the mobility impairments where the extra value of the property for improvements is not taxed. So I'm going to hop on to the different credits and exemption for veterans. So for a long time, New Hampshire has had a standard veterans tax credit of $50. That's mandatory. And then the municipalities can increase that to as much as $750. And the requirements are very specific. It requires some active service during certain conflicts. And then there's a list of the different conflicts. So, and some of the, as you can see, some of them are probably kind of moot by now, given how long ago they were, or almost, sadly. But now, more recently, the legislature enacted an all veterans tax credit. So if a municipality chooses this tax credit, it takes the place of the former veterans tax credit. And again, this one doesn't require service in a specific conflict. It just requires a person shall qualify for the all veterans tax credit if the person is a resident of the state who served not less than 90 days on active service in the armed forces of the US and was honorably discharged, or an officer honorably separated from service. So again, this applies, if adopted by the municipality, applies to all veterans. And the amount it says, shall be amount from 50 to 500 for the optional one. I'm hopping ahead. This is the next one. This is an optional tax credit for combat service. So this is for people presently in combat service. And that's an optional one. To qualify for the tax credit for combat service, a person shall be a resident of the state at any point during the taxable period, or in this shall be a resident of the state engaged at any point during the taxable period in combat service as a member of the New Hampshire National Guard or a reserve component of the US Armed Forces called to active duty. A tax credit for combat service shall be in lieu of and not in addition to the optional veterans tax credit or the all veterans tax credit. There's a tax credit for a surviving spouse for $700, and a municipality can increase that for up to $2,000, anywhere from $701 to $2,000. Then there is a tax credit for service-connected total disability. Again, the minimum amount is $700, and the municipality can increase it anywhere up to $4,000. There is a total exemption for veterans who own a specially adapted homestead, which has been acquired with the assistance of the Veterans Administration. So that person is exempt from all taxation on that homestead. I'm going to skim over this a bit. This is miscellaneous provisions related to the different tax relief statutes, a section of definitions. And again, I'm including this because I really wanted to have comprehensive slides, but some of it really gets into a lot of detail. Proration of the tax credit, how husband and wife are treated. Each qualifying for a tax credit shall be granted a tax credit upon their real estate. Veterans of allied forces. The application process for an exemption or a tax credit includes the deadline of April 15th. There's also a provision here that under certain circumstances, the deadline could be extended if a person otherwise qualified to receive an exemption or credit shall satisfy the selectmen or assessors that he or she was prevented by accident, mistake, or misfortune from filing a permanent application by April 15th. And then notwithstanding the April 15th application deadline in paragraph 1, a person may apply for the tax credit for combat service at any point during the tax year in which the person engaged in combat service. Then there are the procedures for the adoption, modification, or rescission. So these are the this part of the statutes addresses the procedure if a municipality wants to raise some of the or include some of the optional exemptions or credits. So this statute talks about the process for deciding whether somebody qualifies. So the selectmen or assessors shall examine if as to the right to the tax exemption, the tax deferral, or the tax credit. For those exemptions having income or asset limitations, the assessing officials may request true copies of any documents as needed to verify eligibility. It also refers to protecting the privacy of the individual and returning documents after a decision is made. And again, this is where that form comes in that the Department of Revenue Administration has that is useful as far as collecting that information. The statute doesn't require that form to be returned by the deadline in the statute, but obviously the town would need it, to act on the request. On or before July 1st, prior to the date of notice, the selectman or assessor shall send by first-class mail a written decision to any taxpayer who timely requests an exemption or tax credit. On or before July 1st, following the date of notice of tax, the selectmen or assessors shall send by first-class mail a written decision to any taxpayer who timely requests a deferral. So again, the deferrals are for the preceding year. The exemptions and credits are for that year in which the application is made. Failure to respond shall constitute a denial. So this is kind of a difficult point because a lot of people don't know that failure to respond is a denial. So I'm not sure if it's mentioned on the form. I hope it is mentioned on the form, but again, it's in small print. But I would hope that municipalities make an active decision and not just no decision, so that people know that they can appeal it at that point. Whenever the selectmen or assessors refuse to grant an applicant an exemption, deferral, or tax credit to which an applicant may be entitled, the applicant may appeal in writing on or before September 1st, following the date of notice of tax, to the Board of Tax and Land Appeals or the Superior Court, which may order an exemption, deferral, or tax credit or an abatement if a tax has been assessed. So that's the appeal provision. The Board of Tax and Land Appeals is obviously very familiar with these, so I certainly would say in most situations that would be the route to go. So abatements are provided for under RSA 76:16C. Very brief, selectmen or assessors may, for good cause shown, abate any resident tax assessed by them or their predecessors. And I already read this before in the context of deferrals, but again, this is the key statute that is New Hampshire law. Or sorry, this is the key case that is New Hampshire law. It's not in any statutes, but this is applied by pretty much all municipalities as far as the standard for when an abatement is granted. We hold that plaintiffs who claim that they are entitled to an abatement because of poverty and an inability to pay, and who have some equity in their homes, must show that it is not reasonable for them to relocate, refinance, or otherwise obtain additional public assistance. And that has been held as a very stringent standard in a lot of situations. I mean, I would hope that municipalities take a lot of factors into consideration. Again, if facing a vulnerable or older adult that is trying to stay in their home, and really if they have no other options, whether they will abate taxes. And the form that is on the Board of Tax and Land Appeal website actually contains reference to the language so that the taxpayer homeowner is actually directed to explain on that form, why is it not reasonable for them to relocate, refinance, or otherwise obtain additional public assistance. And this just goes into, again, more of the statute on this. So key is, it used to be that it was only for just the past year's taxes, but the statute was amended. The selectmen or assessors for good cause shown may abate any tax, including prior year's taxes assessed by them or by their predecessors, including any portion of interest accrued on such tax. So the statute now includes old taxes, and also interest accrued on those taxes. And I recently saw a situation where somebody actually, again, a person that is older, lives in a town with a very high exemption, especially for people that are 80 and plus. And the person is living in a mobile home. So now all of their taxes, the exemption is more than the value of their mobile home. So they don't have to pay any more property taxes, but that person has some old taxes due, like, let's say, I think maybe $2,000 are left of taxes from several years ago. The person's income is a very small amount of Social Security benefits, less than $1,000. And I think the municipality is considering whether to abate the taxes of that person. Certainly, in that situation, I would hope that the municipality is willing to forego a couple thousand in taxes to allow this person that's around age 80 to keep residing in their home as long as they're able to. And again, this is more of the abatement statute. This goes into the appeal process, the filing fee with the Board of Tax and Land Appeals, the September 1st deadline. The Board of Tax and Land Appeals, if a homeowner, a taxpayer files an appeal, then sends a request to the municipality for some documentation. Sometimes there's an attempt at mediation or alternative dispute resolution. Sometimes it goes straight to a hearing. I haven't figured that out when which is offered. More about the appeal statute. This is the option for appealing to the Superior Court. And again, this is in lieu of appealing to the Board of Tax and Land Appeals. Interest, whenever after taxes have been paid, the selectmen, the Board of Tax and Land Appeals, or the Superior Court, as the case may be, grant an abatement of taxes, they shall award interest on the amount of taxes abated at the rate of 6% per annum from the date the taxes were paid to the date of refund. So this is another point, and again, different minds may have different opinions on this, but I will provide my opinion, and others are welcome to obviously provide input on their opinion. So the New Hampshire statutes require the notice. This is the minimum notice that's required of on the tax bills or on a separate paper. If you are elderly, disabled, blind, a veteran or veteran spouse, or are unable to pay taxes due to poverty or other good cause, you may be eligible for a tax exemption, credit, abatement, or deferral. For details and application information, contact, and then you put in the contact information. So this is the minimum information required on the tax bill or in a separate paper with the tax bill. And this is what's really important. This statement shall be prominent and legible. Legible is not usually a problem. Prominent may be, and prominent is not defined in the statutes in this situation. And sorry, I should just say, so again, a municipality may in its discretion choose to include more detailed information. However, that the information above is the minimum. So this is an old tax bill. You can see it's from 2009. So I'm looking here for the information about property tax relief, and I'm going to zoom in on this one on the next page. So, and I'm sorry, this is a scan of a scan of a scan, so it's not very good. But here it says information to taxpayers, And then here it says, if you are elderly, disabled, blind, a veteran, so it provides that statutory information. And this was actually, we brought this to court on an injunction, and we did get a temporary injunction on this one. And the court in this case found that talks about that it shall be prominent and legible, and either printed on the tax bill itself or on a separate sheet of paper enclosed with the tax bill. The parties agree that the required minimum language appears on the tax bill, but disagree about whether the notice is prominent and legible. And then it talks about, it just does a sort of a statutory analysis, as a court will do. Looks at dictionary definition of prominent and legible. And then the court finds here, the court applies these meanings of the statutory terms to the notice provided on Mr. R's tax bills. First, both parties in the court agree that the notice provided was at least legible, that it can be read. Second, examining the appearance of the notice on the tax bill, the court concludes that the notice is something less than conspicuous or noticeable. The language required by RSA 7611A is printed in all capital letters and is located on the bill about halfway down the front of the page inside a box entitled Information to Taxpayers. The box contains a significant amount of text in a small space, with the notice language comprising one of the 5 sentences in the box. Furthermore, all of the text inside the box is printed in smaller type or font than any other information on the tax bill. The fact that the information is printed in smaller font than the other information on the bill serves to de-emphasize the information rather than causing it to be conspicuous or situated so as to catch the attention. Additionally, the effect of the language being printed in all capital letters is diminished by the small size of the print and its placement among several other sentences, all printed in capital letters. The court finds that the notice does not satisfy the plain meaning of prominent in the statute. So again, this is just one judge and one superior court on a preliminary injunction. But again, this is just it's information to consider if a town is looking at their tax bill and thinking about, is the notice prominent? So this is a more recent one from the town of Pittsfield. Here there's notice information on the front of the tax bill. It is this part, obviously the 8% interest rate charged is, it looks like it's bolder and bigger, and this looks smaller. Then there is additional information on the back. So this is more detailed in all caps. So again, I'm not saying, this is enough or this isn't enough, but again, I just really encourage municipalities to think about what will it take to have people notice it? And I mean, you can't make people read all and everything on a notice, but I do hope that municipalities think about what will catch the attention of people that need this assistance. And finally, I wanted to, another thing that we often focus on is that the New Hampshire Supreme Court has found that under Part 1, Article 1 of the New Hampshire Constitution, town officials are required to provide meaningful assistance to all citizens who seek their help in resolving municipal related issues. So we as advocates for usually low-income homeowner taxpayers, we feel that it really is the duty of the town or city, if they are aware of somebody coming in and asking for or saying, I'm having trouble paying my taxes, then I really, really hope that the town or city employees and staff will tell the person, this is what there is. Okay, the person, looks like they're, 55, and you're thinking, oh, this person is never going to be available for, is not 65 and over. Still let them know, maybe they are 65, maybe the spouse is 65. But again, I would just very broadly let people know about what is out there, and, and try to direct them to the right places for help if they have questions.
We have one comment, Ruth, I just would share with you. This has to do with the information which is printed on the tax bill.
Yep.
And the comments is as follows. I'm sorry, but you have to remember that some of the programs, and I think she's referring to the software programs that towns use for tax billing, really don't leave a lot of room for messaging. And, this particular person is saying we do our best. So, it's a good point, because many of the, the taxing mechanisms used are through software programs, and maybe there's a need to speak to the software vendor to improve how appropriate messaging can be put on tax bills.
Yeah, and that would be exactly that would be great. That's yeah. And I really understand the limitations, but I would definitely encourage municipalities to talk. I think I can't remember how many vendors there are, but to talk with the vendors who provide the software for the forms to include language that really does give meaningful notice. Go ahead. Shoot. Okay. Oh, sorry. My mouse just. Oh man. Okay, sorry. My mouse just went. Okay. So additional resources. So we provide an 8-page pamphlet, which is very dense. I don't know if anybody reads it, but it's created by our Justice and Aging Project that it has fairly comprehensive information about property tax relief. And that's available on our website. And we're also willing to mail it to people or email it. Can reach out to our email or phone. This is for one of my colleagues, Donna. She can get that information to you. We also have a 2-page information flyer. It's intended to be printed double-sided. Great to just have it sitting out somewhere. And again, I can provide copies or a PDF. And then we're just finishing up an 11-by-17 poster, which is a lot more bare bones information, but really to alert people. So we can also provide that. If there's some way I can get some to the Municipal Association, we can provide that too, provide a stack that can be shared. But those are resources that we have as far as getting out the word to taxpayers. And then also, if taxpayers want assistance, that's our contact information for 603 legal aid. And then a lot of cases get referred to New Hampshire legal assistance. So I'm not sure why oh gosh. Okay, so I need to get rid of, I don't know, I'm getting these, God, I don't know why I don't know if everybody's getting the thought. So that is the end of what I wanted to share. And I don't know if anybody has more questions right now or want to take a break and then hop into to Stephen's presentation.
I would say let's go ahead. Let's move forward. I feel a need to get my materials going. So if you could stop sharing your screen, Ruth, I could share my screen.
Okay, and Ian, so are you now able to share screen?
I should be able to. You should see my screen now.
Great, excellent.
Hold on. So are you still seeing my screen?
Yes.
Okay. So I again, thank you everyone for joining us today. My purpose here is to try to give, local officials an insert. It sounds like I've paused my screen share. Do you still see my presentation?
I do.
Okay. I'm going to resume sharing. Okay. I just had to hit a button that says sometimes these Zoom controls are a little confusing. So hopefully everyone can see my materials. As I said before, I'll make sure Ruth gets a copy of this presentation so that, oh, great. Dawn, give me a thumbs up. Thank you, Dawn. I will make sure that a copy of these materials will go to Ruth as a PDF. Would be 2 slides per page. And then you can, Ruth, you could send this out to those who registered. You'll have the email address that can send it to them. So I'm your legal services counsel. And what I really just wanted to do was to give you a brief insight into the statutes and the content of warrant articles you might use to implement some of these tax exemptions, credits, and deferrals. A little bit of overlap from what Ruth has presented, but I'm going to kind of emphasize which I think are the important points for municipal officials. So number one, this elderly and disabled deferral, and by the way, it's both elderly and disabled. The person has to be 65 or eligible under Title II or Title 17 of the Federal Social Security Act. So eligible would mean they're receiving SSI or SSDI. So one of those characteristics would be a person who would be eligible. So it could be either 65 or they're on SSI or SSDI. They've owned the home for 5 consecutive years or has owned the homestead at least 1 year if the person qualifies as disabled and is living at the house. The tax deferral has to be no more than 85% of the equity value. And I've been thinking about this. How do you go about deciding what's 85%? Well, I think as Ruth pointed out, the form would require you to get the consent of the mortgagee in the event that is the mortgage holder of the mortgage on the property. So at that process of getting the the mortgagee's consent, the consent of the bank, you would want to get the number in terms of what's the outstanding values. Now, the other part would be, I suppose, are there other liens of record? So that becomes a little trickier, and I don't have a complete inventory of ways you would do this, but if it's a simple house with one mortgage, the mortgagee has to consent to the deferral, you're going to be able to get that number so you can know what the liens are, and then you're just going to take that number, subtract it from the current assessed value, and try to determine whether or not the deferrals you're going to grant are going to stay within that 80% range. That is, you're not going to grant deferrals that exceed 85% of the equity, taking into account those liens of record or mortgages of record. Filing of the application, of the deferral will be permanent unless the person changes residency, obviously. But the town has the ability to do annual application updates and evaluations. So if you're concerned about a particular deferral going into a point where it exceeds that 85% equity, you may have to stay on top of and monitor that particular deferral to make sure you don't exceed that level and become a problem where those who are discussed in the chat become something that has to be tax deeded. And I've already indicated that, the property, you have to get the mortgage company's permission to do the deferral, but understand you're going to be you're not going to get a preferential lien by recording the notice of the deferral. You're going to be still subject to the mortgage holder. And that's, of course, the reason why you're going to minimize the granting of this to no more than 85% of the equity of the property. This is the statute. I actually copied and pasted this warrant article that would be used to adopt or modify the elder exemption. And these are the variables you have to modify as you decide what the level of the exemption is for the elderly. And actually, I copied and pasted this straight from the suggested warrant article document, which DRA used to have on their website, but it's not there now because they're updating it. And so the question is, before I go any further, so a person who has filed the PA 30, say in 2021, doesn't have to over apply again as long as they don't change residence. That's the law. Doesn't mean you have to go that route, but you can deem it to be a permanent application. That is correct. So again, back to the adopt, modify the elderly exemption. This is the actual warrant article as suggested by DRA. And these are the things that you would modify in terms of the level of the amount of the exemption and the net income and assets for the people who would qualify. I do want to mention about the modify the blind exemption. I know that Jim Michaud is on the program here and was sending in some notes about this. And I'm not sure I agree with him about you have to adopt the blind exemption. And I'm just going to read the statute to you. It seems pretty clear to me. The statute says, if someone, hold on a second, is determined to be blind, according to the Blind Services Bureau of Vocational Rehabilitation, they shall be exempt each year on the assessed value for their property of $15,000. I'm not reading that statute 7237 as being optional. I'm reading it as you've got to grant that as long as they can qualify as being blind according to the blind services program, the Bureau of Vocational Rehabilitation. So, and I also read the statute as saying, but then the town can decide to grant a greater exemption. So that's how I read that statute. I'd be happy to be found incorrect, but it seemed that that's the correct reading of that requirement under 7237. There is this other statute that allows exemptions for improvements to assist persons with disabilities. So everyone who owns a residential real estate to which he's made improvements for the purpose of assisting a person with a disability is each year entitled to an exemption from the assessed value for the property taxes by deducting the value of those improvements. And the statute also gives you a definition of what a person with a disability is. So there is going to be a little bit trickier piece of work for the municipality to evaluate the improvements and the disabled person, but clearly that is an opportunity that someone has to get that exemption from assessed value for those improvements they put into their property, such as ramps and other attributes to a home that make the premises more livable for a disabled person. The exemption for the deaf, also, in my opinion, 72:38-B is one where they, as a deaf person, are exempt each year to their assessed value of an amount up to $15,000. That's a required exemption. And then the city or town can decide to increase that exemption. And you would do that in the same manner as other exemption changes. You would adopt a warrant article to increase that exemption. So I read 72:38-B as a mandatory requirement that if you're deaf or severely hearing impaired, you would get that exemption or assessed value of up to $15,000. There is this opportunity also to modify the disabled exemption. So the exemption for disabled from property tax based on assessed value for a qualified taxpayer, you can modify that so that the amount of the exemption and the net income and assets can be modified. And I see that Michelle Lutz says, I would agree with Jim that deaf and blind are optional. I have a booklet put up by DRA that lists them as optional exemption. Okay, Michelle, I'm prepared to understand that that's what DRA says, but looking at the statute, I'm finding it hard to believe it's optional when the statute says every inhabitant who is legally blind shall be exempt each year on the assessed value for property tax purposes of his or her residential property to the value of $15,000. That's how I read it.
Stephen, it's interesting because the form also lists it under the optional, but again, the New Hampshire Supreme Court has always interpreted shall as mandatory. So, I
don't want to get into a tiff with DRA or with those of you on this program. I'm just telling you that when I sat down to prepare these materials, I read shall as shall. But I will defer to the more experienced, those who are practitioners here, but at least that's what I observed by looking at the statutes.
It's a very interesting question, and I would agree. It's up in the air. It really is.
Just a few things. Jim is citing to 7227A. Let's see what 7227A says. 7227-A. Procedure for adoption. I'm not sure I can get into a detailed recitation and exegesis of these exemptions at this point. Jim, I would love to be able to do that. And certainly we can submit a supplemental clarifying piece of information. And I'll be happy to look at that later. So moving on to the standard and optional veterans tax credit. Just to remind everyone, the way we have in New Hampshire set up this a credit for the benefit of those who are veterans is to give either a standard or optional tax credit. And then we have the all veterans tax credit. So the standard credit is $50. The optional tax credit can be a $51 to $750, which is adopted by the town. And so either the standard veterans tax credit or the optional tax credit is subtracted from the property tax on the veterans residential property. But to continue the thought with regards to the veterans tax credit, there's this all veterans tax credit. So the difference is the standard and optional veterans tax credit was designed for those veterans who served in qualifying disputes, wars, conflicts, and it's listed in the statute: World War I, World War II, Korean conflict, Vietnam conflict, Persian Gulf War, or any other armed conflict that has occurred since May 8, 1975. The all veterans tax credit was really designed to eliminate that requirement. So if the town is going to implement the all veterans tax credit, which has to be adopted by the municipality, it has to, in fact, recognize when it does so, it's going to have a larger number of people who are going to be suddenly eligible, because all you have to do is have served in the armed forces for 90 days and was honorably discharged. So that does broaden the universe of people who would qualify. And in fact, when it was implemented a couple of years ago, I think it was 3 years ago, that particular tax credit, there was municipalities were allowed to phase it in. So those are options you have to go with the all veterans tax credit, and certainly enlarges the number of people who will qualify for that particular tax credit. So the adoption of the all veterans tax credit is, again, something that has to be put on the town warrant. This is the language of the article that would appear. This is available. I was able to provide this content from the Department of Revenue Administration's proposed warrant articles, suggested warrant articles, and this is the form you would use to adopt the all veterans tax credit, which would then make the standard and optional tax credits available to all veterans. And then there are additional tax credits that can be optionally adopted by the municipality. I think Ruth already addressed these. There's an optional tax credit for combat service that can be up to $50 to $500. And then it's subtracted from the property taxes. And this is something the town meeting would adopt to implement additional tax credit for combat service. And then there's an additional recognition of the surviving spouse who under 7229A could, because of the veteran who she or he was married to, was killed or died while in active service. That person, the surviving spouse, would receive a tax credit of $700 for taxes due on the surviving spouse's real estate. And then in addition, there's an ability to modify that surviving spouse tax credit to provide up to $2,000 for tax credits. But these are, again, designed to benefit the surviving spouse because their husband or wife was killed or died during active duty with the armed forces. There is a tax credit for service-connected total disability. So RSA 7235 would grant a tax benefit, a tax credit for service-connected total disability. So the person is permanently service-connected disability or is a double amputee or paraplegic, and they would receive a standard yearly tax credit of $700 on their property taxes. But the municipality, again, can increase that optional tax credit for service-connected disability to up to $4,000. And then certain disabled veterans who, under this statute, have their homes specially adapted, their homestead by the Veterans Administration, and that actual house was acquired with proceeds, the sale of a previous homestead, as stated in the statute, with the assistance of the Veterans Administration. Those are two variables that are available for a disabled veteran who then would be able to receive a 100% exemption on all taxation for that homestead. So it's designed to assist those veterans who get that assistance from the VA because they're 100% permanently and totally disabled. or they're a double amputee or have upper or lower extremities or combination or paraplegic as a result of service-connected injury, or they have blindness in both eyes and other diminishment of their ability to see. So this is really a kind of a special category of disabled veteran credit, which if the person qualifies in 7236A would enable them to have no taxes on their particular homestead and property that's been adapted with proceeds and assistance from the Veterans Administration. So that is really my summary of these statutes, and I will be more than happy to follow up with further dialogue about the blind and the deaf exemptions. But that was my effort to try to supplement the materials that are provided to you today by Ruth. And again, I'm going to have to rely on Ruth and her colleagues at Legal Assistance to send out PDF copies of my slides.
Great. And so I just posted my email on here, so I don't know, because we didn't do like a formal registration. It was more just, I think, signing up to get the link. So I'm not sure if Ian, are you able to post the two PowerPoints in the dialogue? And Stephen, is the one that you sent me a few days ago, last week, the one that you used today?
Yes, it is.
Okay, so I don't know, Ian, I emailed both of you. I don't know if Ian, if you're able to like include those somehow so that people can access them in the chat, or how that's done. If not, just email me and I can get both of them to you. And I don't know if anybody else had any other questions and at all for Stephen or me.
It looks like we've covered the topic, Ruth. I don't see any more questions coming in on the chat.
Great. Well, I really appreciate, first of all, and most of all, I appreciate, Stephen, that you were willing to work together in getting out this information. I think this is just really important for as many people to know about what New Hampshire has, because I think it's very unique, just the options that are offered within New Hampshire to help taxpayers that are struggling to pay their taxes. And I really appreciate all the points that were made by the participants. So I really appreciate that as well. So
well, thank you, Ruth. I think that you've covered a broad area in a succinct way, and I'm sure that it will be helpful to municipal officials to understand their role in dealing with exemptions, credits, deferrals, and abatements.
Great. And please email me as far as getting the PowerPoints. So, and it's I put it in the chat. I'll just say it. It's my first initial last name. It's RHEINTZ@nhla.org. And I'm also going to get them to Erica Anthony. She's been working with Stephen and me on this as well. So I'll get them to Erica Anthony because I do have her email. So great. Thank you again.
Thank you all.
Okay, thanks.